Hello, everyone, and welcome to Uncivil Law. For today's case, we have a situation where a person reported being robbed, and then the police decided to conduct a search warrant on the place that had just been reported as robbed, and they shot and killed the owner who reported the robbery. So he got shot for the trouble of reporting that his place had been broken into. This is the case of Teresa Hooks versus Christopher Brewer. In this case, the police came into some information which was very unreliable, conducted a warrant under very suspicious circumstances, and a person is now dead. So let us discuss whether or not we can sue the police for their many Benny Hill-like errors on this one. Let's get started with this. In 2014, David Hooks called the Lorenz County Sheriff's Department to report a robbery on his property. Several items, including a car, went missing, so we asked officers to investigate, and they did. The next day, Hooks was dead, shot and killed in his home by the same police department he had called seeking for help. So, yeah, the police department, he's like, I have been robbed. My car has been stolen. And the next day, he is shot by the very same police department he reported to. That's great. Let's find out how that happened. As Teresa Hooks got ready for bed one night in late September of 2014, she looked out an upstairs window and saw several men clad in dark clothing running towards the back of the home. Her husband was asleep downstairs. The day before, the Hooks property had been robbed, so when dark-clothed men rushed towards the door shortly before midnight, Teresa was alarmed. You don't say. Having just been robbed, they are a little bit antsy. She ran downstairs, banging on the walls to wake her husband. Hooks emerged from his slumber naked, holding a shotgun, and asked his wife what was happening. The Hooks feared again they were being robbed, which is a reasonable fear, having just been robbed, that there are now men coming towards your door at midnight, and she's banging on the door. Help, there's people coming towards the house. And he comes with a shotgun, and he's thinking to himself, they're back for more. But it wasn't the bad guys, it was the good guys. But the men at the door were not there to break the law. Although they did. We'll get back to that in a second. They were the law. Believing Hooks to be involved in the meth trade, and how they came into that belief is very shaky. Members of the Lorenz County Sheriff Response Department had come to execute a search warrant. At midnight, officers breached the door, and a second later, they fired 23 shots. Hooks suffered fatal wounds. So, yeah, is this insult to injury, or is this injury to injury? Is this injury squared? I don't know. But this guy, he lost his stuff, he lost his car, and now he's lost his life from two different bandit groups. So how did this all come to be? So we need to learn a little bit more about what happened leading up to this. So let's discuss what happened the previous day. To understand what led up to the shooting, we must go back to the day before. That is when Hooks noticed things missing from his property in East Dublin, Georgia, including his car, a Lincoln Aviator, and several guns. Yeah, his car is stolen, his guns are stolen, and he does what he's supposed to do, right? He reports this to the police. Okay. But something else happened along the way. At the same time all this was happening, or, contemporaneously, Sergeant Brooks received a call from Beverly Garrett that her husband was having health issues. In truth, though, the Garretts lured Brooks over to them because they wanted their son, Rodney Garrett, to turn himself in. Garrett had the Aviator in his possession, so Brooks ran the VIN number and the vehicle came back stolen. It was from the Hooks property. All right, so these parents have called the police to get their son essentially arrested, to turn himself in. So these other people, who are also being good civic people, I suppose, call the police, and they lure their own son over on the pretense that they're having health problems, which isn't true. And they also call the police over to essentially have him turn himself in. And so the police come over and they find the car, the Lincoln Aviator, the one that was stolen earlier that day, right? So huzzah, we have found the stolen car. And we know we have the guy who it was in possession of, which is a pretty big clue. So we can arrest him and return the car and be done with it. But no, there's more. Garrett explained that he had wandered down the highway and randomly came across the Hooks home, walked up the driveway, and noticed the Aviator was unlocked, which I guess is superficially plausible. This is where it becomes a little bit less plausible. So was another vehicle on the property, which is also unlocked. And in that car, Garrett, who's the criminal, remind you, the guy who's in possession of the car, Garrett took digital scales, some money, and a bag. Then Garrett said he went into Hook's garage, took some shotguns and a rifle, and returned the aviator with his loot to drive off. Garrett, the guy who stole the car, stopped at a gas station, opened the bag he stole, and noticed a large amount of methamphetamine inside of it. Garrett, a known meth user who was admittedly high when he stole the property, said the drug quantity scared him. Oh, only a well-connected dealer would have so much meth, Garrett said, so he thought best to turn himself in. So Garrett's claim here, Garrett's claim here, which apparently the police found to be totally plausible and didn't need any more explanation, is, I was walking down the street and I decided to walk onto this particular property for no particular reason. And I noticed 2 different cars were unlocked and apparently also had the keys inside because I was able to steal them, but whatever. This Lincoln Aviator and a different car. From this other car, I retrieved some scales and a bag. And when I opened the bag, I noticed large amounts of meth. So I just stumbled upon this huge meth dealer who left a bag full of meth in their car unlocked. This was his claim. And the police know that Garrett over here is also a meth user. So they didn't think to themselves, maybe he's not telling the full truth. Maybe he's lying. Maybe this didn't happen because that doesn't really make any sense. No, they didn't exercise any sort of critical learning skills or critical consideration skills. They didn't say to themselves, you just walked onto a random property and the cars were randomly unlocked and there was a bag in them full of meth. That's your claim. We're not going to apply any sort of skepticism to this. Nope. That sounds totally like what happened. Let's get a search warrant against the people who had their house broken into because of the bag of meth this guy found, who we're going to believe, even though we know he's a meth addict. That's great. Let's do that. Back at the sheriff's officer, Sergeant Paget, Brooks, Brewer, and Burns questioned Garrett, who relayed the same information about the drugs and gun. I totally came upon this bag of meth sitting in a random car. Garrett also told the police he regularly received meth from his friend Chris Willis, with whom he lived in a tent in the woods. Garrett denied knowing Hooks, but the police believed they had enough to search the property. Yeah, so him and his meth buddy live in a thing in the woods. And it's like, I have this huge thing of meth. I found it in this car. And the police are like, yes, you found it in the car. That sounds like a thing that definitely happened. Let's not investigate any further. Let's get ourselves a search warrant and bust down their door. Thus, leading us to the warrant. Worried the Hooks might learn about Garrett's arrest, even though Garrett said he didn't know Hooks, incidentally, so I'm not sure how, Brewer acted quickly to obtain the search warrant. In the warrant affidavit, Brewer included the Garrett information, as well as information from a prior investigation involving a man named Jeffrey Frazier. In that case, from 5 years earlier, Frazier told the police he supplied Hooks with meth from Atlanta. So this guy Frazier, 5 years earlier, said, I gave Hooks meth. They didn't do anything to investigate it 5 years ago, but apparently that's a thing. Both Brewer and Burns investigated at the time, but nothing ever corroborated the claim. So they investigated this, and they didn't find anything to corroborate it. Yet, the warrant stated, your affiant, the affiant is a name of a guy who's making an affidavit, right? That's the affiant. So that would be the police officer in this case. So your affiant is the police officer. So let me rephrase that. This police officer is familiar with residences and the occupant of the residence, David Hooks, from a prior narcotics investigation involving Jeff Frazier. During this investigation, Frazier had been interviewed by law enforcement and stated he had been the source of supply for multiple ounces of methamphetamine to Hooks, who Hooks was redistributing. So even though 5 years earlier they investigated and found nothing to corroborate it with and found it to be uncredible because they stopped investigating, 5 years later they tell the magistrate, we found this to be credible, even though you investigated 5 years earlier and found it not to be credible. Thus, the magistrate judge signed the search warrant at 9:56 p.m., just over 2 hours after the police had interviewed Garrett. We are running to the courthouses on this one. Officers then decided to bring in the sheriff's response team to execute the warrant that evening. In the middle of the night, which, Shouldn't be doing that. Moving quickly was important, Brewer claimed, because the police had concerns that Hook could destroy evidence. Okay? During the meeting, officers discussed the fact that Hooks had just been robbed and had weapons on the property, so they were told to be on high alert. Yeah, that seems like the kind of thing you might want to be on alert for. The guy just been robbed. He might be a little bit jumpy. Are you sure you want to do this in the middle of the night? Are you sure you don't want to announce police? Are you sure you don't want to investigate more to figure out if any of this has any credibility? You know, the guy's house was just robbed, right? You could probably just ask him to come into the home. You're right. You could just, so here's a suggestion. If you wanted to do this, you have a pretty good reason for the homeowner to let you in. So you could be like, I know your property was just robbed. Do you mind if I come in and look around a little bit, to see if there's anything else that was stolen, or to take a note of things for my report? And then you can look around and see if there's any evidence of drugs or whatever. That might be an idea. And if they say no, then there are other tactics beyond that. But, we don't want to try any of those things. We just want to bust down their door at midnight, even though we know they're jumpy. Great. Deputy Cassie Lloyd, an officer involved in the execution of the warrant, said he saw a man and a woman through the back door, and police knocked for about 30 seconds before entering the house. Who believes that? Who believes they knocked for 30 seconds? In fact, what's the probability they knocked at all is a reasonable question, but okay. At that point, Hooks ran towards the dining room, shotgun in hand, being a little bit jumpy. That was the last time Teresa saw her husband alive. Seconds later, the police fired shots, killing Hooks after one of the officers claimed he raised his gun. So the cops of the year over here believed the drug dealer that, yes, I just found a huge pile of meth in this guy's house. And on that basis, and a completely uncorroborated claim from 5 years earlier, got a search warrant, decided to conduct a middle-of-the-night raid, and the guy is now dead. Thus, bringing us to the lawsuit. Teresa sued the officers on behalf of her husband, who is now dead, as well as in her own capacity, alleging that in the search of the home, the shooting death of her husband and detention in violation of the Fourth Amendment, she claimed the police included false information and omitted key facts in the affidavit, making it, and the warrant, invalid. Invoking qualified immunity, everyone on this channel's favorite doctrine, the officers moved for summary judgment, but the district court denied the motion. Okay, so we need to figure out whether or not this warrant is any good. So to figure out whether or not this warrant is any good, we need to discuss the standards that govern warrants and to figure out if it was actually valid. So let's discuss the standards that go over warrants and whether or not this warrant was actually valid or not. The Fourth Amendment to the Constitution, which, if the police have forgotten what it is, I'm more than happy to give them a copy. It says, no warrant shall issue but upon probable cause, supported by oath or affirmation. Like, you actually have to tell the truth. Kind of in the Constitution. It's in the Constitution. It's explicitly mentioned. You can only get upon probable cause upon an oath to tell the truth. So, yeah. Usually a warrant establishes probable cause, but not when the magistrate issuing the warrant was misled by information in an affidavit that the affiant knew was false or would have known was false except for reckless disregard. So, amazingly, you cannot lie in an affidavit. It's a constitutional violation. It's a criminal violation just to lie in an affidavit, because that's what we call perjury, because you're under oath. So there's that. So it's normally just criminal to lie. It's also a constitutional violation to lie when you're doing it for the purposes of obtaining a warrant, because the warrant has to be issued upon an oath or affirmation, and you just lied. So that basically you just violate the Constitution, in addition to committing perjury. Genius. Great. That's wonderful. Way to go. Probable cause is not a high bar. The mere probability or substantial chance of criminal activity is all that's needed. It's pretty low. Maybe like 0.5 on a scale of 1 to 10, but it's something. The police need not resolve every inconsistency found in the evidence. Officers just need to have a reasonable basis, given the totality of the circumstances. At the same time, and notably, however, the affiants who are making an affidavit under oath cannot lie or admit critical information, because a lie of omission can be a lie. When it's critical, you need to tell them about it. To determine if an officer's conduct invalidates a warrant, then, we first ask if the affidavit included any intentional or reckless misstatement or omission. An intentional misstatement, otherwise what's called a lie. Recklessness occurs when an officer should have recognized the error or at least harbored serious doubts about the information. Taking all the inferences in the person who's suing's favor, the officer is not entitled to qualified immunity. First, the officer made reckless misstatements and omissions. For example, the affidavit recites that Frazier told Hooks was redistributing meth, but Frazier never actually said that. Frazier only said, I was supplying, not that he was redistributing. So that itself was also a lie. Indeed, Corporal Burris, the person who interviewed Frazier at the time, could not remember saying Hooks provided any meth to a third party. So even that was a lie. First of all, according to the guy who made the statement to the judge, according to that guy, he said that Frazier said that he was just supplying, not redistributing. So that was lie number one. And then the guy who actually conducted the interview said, wait, Frazier never said that he'd redistributed to anybody in any capacity whatsoever. That would be lie number two. We're chalking them up over here in Georgia. Qualified immunity thus does not protect Brewer's conduct. Indeed, an officer must make some basic investigatory steps. That would have been nice. Brewer was not required to turn over every rock to confirm Frazier's story, but he should have done something. Anything would have been nice to confirm the affidavit's accuracy. Anything at all. But no. And on this point, the record does not establish that as a matter of law that Brewer did so. So Brewer doesn't have to turn over every rock. He just has to do something. A thing that would validate that Frazier was telling the truth. Anything would be fine. Also, Frazier never said that, so it'd be hard to validate. Okay, great. Still, the misstatements and omissions must be material to probable cause determination. I love how we call them misstatements. When you do that intentionally, another word for that is lying. Here, that would have meant eliminating Garrett's other crimes information and the fact that Frazier said that Hooks distributed drugs, which he never said that. And it means including the 5-year-old investigation turned up no information on Hooks. And none of the other Frazier's claims had ever been corroborated. Here is shocking news of the year, apparently to Georgia. Apparently, the Georgia cops don't know this. So this is apparently shocking news. Are you ready for this shocking news? It is possible a person taking meth might lie. All police would have had in this new affidavit is Garrett saying he stole drugs from Hooks and questionable information from Frazier. Nothing would support drugs in the Hooks home. The question is, does this amount to probable cause to search the home? We think not. It's a little thin. I mean, again, probable cause is like 0.5, 0.75 on a scale of 1 to 10. Probable cause is pretty low. That's how low it is. It's below the scale. It's not 0 though. So yeah, it's not nothing. And even this is too low for the threshold we're normally on. But last, we must come to the real part of this discussion for all those who had hope, right? We've learned all the bad things that they did, but we can't get past the question we must now ask. You know what the question is. It was a show starring Stephen Fry on British television, and that show is QI. Let's discuss QI. This is a qualified immunity case, and that means plaintiff must show defendants not only violate constitutional rights, they violate clearly established ones. That typically means binding precedent controls the case, but such precedent need not be identical. It need only to squarely govern the case. And fortunately, and thank God, plenty of authority does. Misstatements and omissions, again, misstatements are what known as lies. Misstatements and omissions in affidavits pierce qualified immunity only when the new affidavit lacks even arguable probable cause. So, yes, this is not the first time that a court has had to do this, so thank God. There is clearly established. You cannot, in fact, lie, or I apologize, not lie, make misstatements. You can't make misstatements on an affidavit. No, you can't do that. Also, it was clearly established by the text of the Fourth Amendment itself, but we know that doesn't count. But fortunately, we have cases that say it, so that's nice. However, it's not all good news because there's other officers involved. So we have to reach, unfortunately, the opposite result for Verton and Harrell. So some other officers are going to get excused. As to Verton, Teresa argues that he illegally detained her outside the house. But at the very least, Verton did not violate any clearly established law, so he's entitled to qualified immunity. Officers can temporarily detain occupants of a house while executing a search warrant. Yes, they can. Yes, the Georgia Bureau of Investigation took over the investigation, and Lawrence County officers never executed the warrant they intended to, but there's no authority, let alone clearly established authority, that suggests this distinction makes a difference. We don't really care what police officers executed the warrant at the end of the day. Was it the local cops? Was it Georgia Bureau of Investigation? We just don't care. As to Harrell, the unlawful detention claim fails because Verton is entitled to qualified immunity. Harrell must have either directly participated in unconstitutional conduct or there must be a causal connection between the supervisor's actions and the alleged constitutional violations. Neither exists here. Harrell was at the warrant execution meeting, but nothing suggests he was personally involved in the unconstitutional conduct, and nothing shows that Harrell had subjective knowledge of the risk of harm so that hooks he would recklessly disregard. So he keeps his qualified immunity. Yes, so when it comes to these other officers are immune. First of all, as to the supervisors, we know this very well from Monell. We know this as a Monell claim, right? If we want to get to the supervisors, we have to find something they did bad personally. It's not enough that they supervised it. This would be enough for any private organization. If the Domino's worker injures you in the course of their employment, the Domino's manager is responsible. Respondeat superior, vicarious liability. The employee, in the course of employment, has done a bad thing. That makes the employer responsible as the ultimate person that hired you. So if this were Domino's, yes, but it's not Domino's. It's the police. So the police, this doesn't work. Why? Because the Supreme Court says it doesn't. Don't ask questions like that. It just doesn't. So, yeah, you can't do that. You can't say, the employee injured me, so therefore the supervisor is responsible. No, not if it's the police. Literally anyone else, but not the police. So if you want to do the police, you have to show the supervisor themselves did a bad thing. This bad thing might be instructions. It might be training. It might be reckless disregard. It might be blatant ignorance or whatever, but you have to show a bad thing they did. And they didn't do a bad thing, so you can't get to them. You know, this one rogue officer, we had no idea he was going to go off the reservation like that. That's not in accordance to our training. Wink, wink, nudge, nudge, but that's the law. And as for the other officer who was there at the scene, I'm more sympathetic to. You know, he was there. He didn't know. He wasn't involved in any of this. So he's just there backing up his fellow officer. So that guy, a little bit more sympathetic to. But can we get to the supervisor? No. Because the supervisor didn't do anything bad. We had no idea this guy was going to do this. But that's the law. Thus, we affirm the district court's order as to Brewer, reverse as to Harrell and Verton, and remand for further proceedings consistent with this decision. Thus, this is the end of our coverage of the case of Teresa Hooks versus Christopher Brewer. In this case, the Hooks said, "Hey, I've been robbed," and a meth dealer who is totally reliable and trustworthy said, "I found a big pile of drugs in their car." And without doing any investigation whatsoever, they conducted a raid at night and they shot the guy who reported the robbery. So I don't know what the object lesson here is at the end of the day, but except the police do bad things and sometimes they get away with it. But at least for the moment, that's the end of our coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.